Good morning, class. Today we will be discussing the organizational plan, and that includes studying the different forms of ownership so that we can decide what form of ownership we want to establish for our new venture. First, why is it important to select the management team? Number one, it's important for you because your success will depend on how well they do their work. But also it's important for investors because they want to know about who will be working in the company as well as their abilities and their commitment. Talking about commitment, it is a flag for investors if the entrepreneur is not willing to work full-time in the venture. It also would be a flag if the entrepreneur wants to pay himself or herself a large salary to begin with. The other thing that investors will look for is to see if the company has a board of directors or a board of advisors, because then that way they can be sure that decisions are not just being done by one person, but different points of view are being heard and are being taken into account before making decisions that can affect the company. So let's talk about the legal forms of business. There are basically 3 legal forms of business and 1 form. These are the proprietorship, partnership, and corporation. And the 1 form is the limited liability company. Before you write your business plan, you need to decide which one is the best for your venture. And in order to do that, you need to take a look at different factors and compare these so that you can decide what is better for you or for your company. So let's compare them in regards to ownership and liability. In the proprietorship, the owner owns everything, so they have full ownership, but also this means full responsibility. In a partnership, there may be general partners, but there also may be limited partners. The limited liability partnership treats the partnership as a legal entity. In the corporation, which is also treated as a legal entity or legal person, ownership depends on how many shares of stock somebody owns. When we talk about liability, the proprietor in a sole proprietorship is liable for everything. This is very different to a corporation where the owners are only liable for their investment. In the case of proprietors or regular partnerships, no distinction is made between the business entity and the owner. So this is a risk because if there are any outstanding debts of the business, creditors may seize personal assets of the owners. In a partnership, the general partners share the amount of personal liability equally, regardless of their capital contribution, unless, of course, there's another agreement. In a general partnership, there may be some limited partners. The limited partners are only liable for their capital contributions. Limited partners are usually investors. They might not participate fully in the company. They just give a contribution, and that's all they're liable for. Let's talk about these 3 forms of ownership in regards to the cost of starting a business. Generally, the more complex the organization is, the more expensive it will be, which means that the least expensive is the proprietorship. To establish a sole proprietorship is pretty easy. And at the end of the chapter, I'll walk you through some websites so that you can see what you need to do. So for the proprietorship, the costs are very limited. You may only need to pay the filing for a business name. In a partnership, you need a partnership agreement. For this, you need to speak to attorneys, and the partnership agreement needs to be drafted so that it is explicitly stated what are the responsibilities, rights, and duties of everyone involved. A limited partnership may be more complex because it has to comply with statutory requirements. For the corporation, you may need lawyers as well because this needs to be created by statute. A corporation is a legal entity and it needs filing fees, taxes may be incurred, and there will be some legal fees. Let's talk about the continuity of business. In a sole proprietorship, obviously the business is tied to the owner. It's almost like they're one and the same. So therefore, if the sole proprietor passes away, that terminates the business. In a partnership, if a general partner passes away, that terminates the partnership. However, if a limited partner passes away, that has no effect on continuity. For the corporation, we can say that that has the most continuity because it is a legal entity and it goes on regardless of who may work in the corporation. Regarding the transferability of interest, sole proprietors are tied to the individual owner. So the owner has control of whether he or she wants to sell or transfer any assets in the business. So if Maria owns a bakery as a sole proprietor and she wants to retire and transfer ownership, she would need to sell the business assets to another individual, and that other individual would then need to form their sole proprietorship, and the transfer of assets would be completed. In a general partnership, transferability is usually governed by the partnership agreement. But it could be complex if a partner wants to transfer their interest that requires the consent of other partners. And it may lead to the dissolution of the partnership if it's not structured correctly or properly. For example, let's think about John and Jane. They have a partnership in a consulting firm. If John wishes to exit, then the agreement outlines the process, whether it may be selling his shares to Jane or dissolving the partnership, or perhaps he needs to bring in a new partner. All of it should be stipulated in the partnership agreement. If they don't have an agreement, or the agreement doesn't address transferability, and that's when disputes can arise. In a corporation, specifically C corporations, those are the ones that have the highest ease of transferability because the shares of stock represent ownership. So they can be bought and sold without affecting any of the operations of the corporation. S corporations have a restricted number and type of shareholders, but still it's pretty easy to transfer shares. An example, Emma owns shares in a C corporation. She can easily sell her shares to another individual through a private transaction, or if it's publicly traded, she can do that through the stock market. In the case of an S corporation, let's say that Alex owns an S corporation. He can sell his shares, but it has to be a qualified buyer. It has to be a citizen of the United States. He can also share to trusts or estates. Now let's discuss about capital requirements. For a proprietor, any new capital the proprietor needs to get, whether that be going to the bank, going to venture capitalists, or going to their family. All of the capital is dependent on the proprietor getting that capital. And so that's where we see that the entrepreneur will take a second mortgage, they might borrow from somebody, and so on. In the partnership, if the partnership obtains a loan from the bank, the partnership agreement will need to be changed. And in the corporation, it is easier to get capital because stock may be sold, or the corporation may borrow money in the name of the corporation. Regarding management control, in a new venture, the entrepreneur will want to retain as much control as possible, whereas in a partnership, the majority usually rules. In the LLP, as you might have guessed, the rights of all partners are stated in the partnership agreement. In a corporation, day-to-day control of the business, any of the operations, they all may be in the hands of somebody who doesn't own any stock, or perhaps they are major stockholders. Decisions in a corporation may require a vote, and as the corporation increases in size, separation of management and control is probable. Stockholders can indirectly affect the operation by electing someone to the board of directors who reflects their personal philosophy. Regarding the distribution of profits and losses, the proprietors receive all distribution of profits, but are also responsible for all losses. In partnerships and corporations, the distribution of profits and losses are subject to different regulations. In a partnership, profits and losses are typically distributed among the partners according to what? You guessed it, the partnership agreement. If there is no agreement, profits and losses are usually divided equally. In the partnership agreement, partners can stipulate how profits and losses will be distributed, and this distribution could be based on a fixed amount, salary allowances, or proportion of the capital that they gave. Now, general partners are personal liable, but limited partners avoid personal liability. In corporations, profits are not distributed directly to the shareholders, but they could be distributed to them in the form of dividends. It is up to the board of directors to distribute the dividends and how much to distribute. Corporations typically retain a portion of the profits so that they can reinvest or to cover future losses. This is known as retained earnings. Example, if XYZ Corporation declares dividends of $1 per share and John owns 1,000 shares, John will receive $1,000 in dividends. This amount will be taxed at his individual income tax rate. The ability to raise capital varies significantly between partnerships and corporations. Partnerships generally have fewer means to raise capital because they primarily rely on contributions from the partners, also from loans and perhaps grants. Partners typically contribute their own funds, or they might secure loans. And when they do that, they might be using personal assets as collateral to finance the partnership. Corporations, on the other hand, especially public corporations, they have more access to capital because they can issue stocks or bonds. If they issue stocks, they can raise equity capital from a range of investors. Investors are often attracted to corporations due to limited liability. And also they like that liquidity aspect that is reflected. And also they like that liquidity because they know that corporations can raise money. Tax advantages and disadvantages differ for each form of business. Only a few of the major 2017 tax law changes are discussed in the text. There are some minor differences that could be important to you. So if you have any doubts, you should seek advice of a tax lawyer. All C corporations will receive a 35% to 25% tax cut, whereas with the LLC and sole proprietors, they will be able to deduct 20% of their business income. Instead of business income being taxed at the individual owner's tax rate, these types of organizations now receive a 20% reduction of their business income. It is said that venture capitalists like the LLC more because regulations now automatically tax an LLC as a partnership. Unless, of course, the entrepreneur chooses to be taxed as a corporation. The S corporation used to be the most popular organizational structure. But growth has declined because now LLCs are accepted everywhere. And S corporation is a special type of corporation that is created through an IRS tax election. The reason it's called an S corporation is that it is named after a subchapter S of the IRS code. It combines the limited liability protection of a corporation with the pass-through taxation of a sole proprietorship or partnership. The main characteristics of an S corporation are number 1, limited liability protection, number 2, pass-through taxation, number 3, ownership restrictions. If you recall, it must have 100 or fewer shareholders. They must be U.S. citizens or residents, and it can only have one class of stock. It also has some employment tax advantages, and to become an S corporation, a company must first be suitable corporation or a limited liability company, and then the owners must file Form 2553 with the IRS to elect an S corporation status. So as an example, let's say we have a person named Lisa. She runs a consulting firm. If she chooses to structure her business as an S corporation, this can help her because she can avoid double taxation that would be typical of a C corporation. So the profits of her firm will be taxed only once on her personal income tax return. However, she has to make sure that she complies with all the ownership and stock requirements of an S corporation. She also needs to make sure that she pays herself a reasonable salary before taking profits as dividend. So let's take a look at the advantages of the S corporation. Number 1, like we said, limited liability protection. So this is similar to a standard corporation like a C corporation. And it means that an S corporation shields its owners from the company's debts and liabilities. Number 2, pass-through taxation. Unlike a C corporation, which is subject to double taxation, an S corporation allows profits and losses to pass through the owner's personal income tax. Number 3, easier transfer of ownership. Ownership interests in an S corporation can be freely sold or transferred without affecting the company's tax status. Number 4, investment opportunities. So S corporations can raise capital because they can sell stock up to 100 shareholders. Number 5, credibility. Being a corporation can give your business enhanced credibility with customers, employees, and so on. Number 6, employment tax savings. While owners must be paid a quote-unquote reasonable salary that is subject to payroll taxes, any additional profits can be distributed as dividends. And these are subject to a lower tax rate than self-employment income. Number 7, established precedents. This is a well-established form of business. And so the operational processes and legal structures of corporations are already well known. and this can make operations straightforward. On the other hand, an S corporation can also have disadvantages. Number one, the type of shareholders. So we already said that S corporations are limited to having 100 shares, and that the shareholders need to be US citizens or residents. Number two, stock limitations. There is only one type of stock. So if an entrepreneur wanted to issue preferred stock, that would not be possible with an S corporation. Number three, complexity and expense. It is a corporation, and so entrepreneurs typically need an attorney support to set it up. Number four, employment tax considerations. As we already mentioned, the entrepreneur would need to pay himself or herself a reasonable salary. And so if the entrepreneur was hoping to pay himself or herself a minimum salary and pay himself or herself through distributions, this would not be possible with an S corporation. Number five, limited fringe benefits. Employee benefits like health, insurance, and meals are not fully deductible for shareholder employees owning more than 2% of the company. Number six, state tax issues. Some states don't recognize the S corporation status. And what they do is they tax businesses as regular C corporation. Number seven, exit strategy. The constraints on share types and ownership can limit options when selling the business or pursuing other exit strategies. Let's now look at the LLC. A limited liability company, an LLC, is a popular choice for entrepreneurs because it's flexible, it's simple, and it has many advantages. Where a corporation has shareholders, a limited liability company has members. And each member owns an interest in the business. So let's say that I own the business with my siblings and I own 25%, my sister owns 25%, and my brother owns 50%, for example. If I were to want to sell my part, I could only do that with the consent of the other partners. Also, as the name implies, limited liability means that if something were to happen to our business, I would only lose the part that I contributed. The IRS automatically taxes the LLC as a partnership. Also, the standard duration of, or the standard life of an LLC is 30 years, but earlier dissolution is possible if it's stipulated in the partnership agreement. One difficulty with LLCs is that the laws that govern LLC can differ from state to state. Now that we have discussed the legal forms of business, let's talk about the internal organization. At the beginning of your venture, the design might be pretty simple because all of the functions might be done by the entrepreneur. However, as time goes by and work increases, the entrepreneur will not be able to do everything himself or herself. Therefore, that entrepreneur needs to identify the major activities that need to be done to function properly within the organization. Based on that, the entrepreneur will need to decide which roles to fill. And so for this, the entrepreneur will need to be able to complete effective interviewing. He or she will need to decide on the workflow and also be cognizant about the internal culture that will form in the organization. That way, the entrepreneur can influence said culture. An organizational structure will be needed, that is to say, an organizational chart. And with that, all of the human resources components that will be needed to manage the organizational structure, meaning all the planning, evaluation schemes, goals and objectives for the employees, rewards, compensation, selection criteria, as well as training. Now that we're talking about the organization, let's take a look specifically at the role of the leader of a venture, the entrepreneur. It could be said that the fundamental role of this person is to be able to adapt to changes and also to be seeking new ideas. Once a new idea is found, the entrepreneur will need to implement it. And in order to implement it, he or she will need to figure out who is going to help with this. Also, the entrepreneur will be putting out fires anytime an issue needs to be resolved, and as well as allocating resources, making decisions about budgets and responsibilities. And finally, the entrepreneur will be fulfilling the role of negotiator because, especially at the beginning, he or she will be the person with the appropriate authority to make decisions, to make important decisions. In designing the organization, the entrepreneur will need to assemble the right mix of people to assume the responsibilities that are outlined in the organizational structure. If you take a look at the first sentence, it says, the team must be able to execute the plan, identify changes, and adjust. So that looks very familiar, right? That looks very much like the fundamental description of the entrepreneur, which is to adapt and seek new ideas and be able to implement them. So when you're looking to hire a team, remember that you're not looking to hire somebody who is just like you. Rather, you're looking for the persons that are needed to fulfill the different functions that you have already decided that you need in your organization. One thing that you do need to consider is the personality and characters, especially the character of each individual. Because the culture is a product of all those individuals that will be working together. And lastly, the entrepreneur should not be afraid to delegate. This might be hard at first because for a while the entrepreneur might be making all of the decisions. However, allowing other people to have a level of authority makes for a very vibrant culture. Like we said at the beginning, venture capitalists like to see that there is a board of directors when the business decides to be a corporation, for example. What do? Well, they review operating and capital budgets. They develop longer-term strategic plans. They support day-to-day activities. They resolve conflicts among owners. They ensure the proper use of assets, and they develop a network of information sources. Lastly, because of the Sarbanes-Oxley Act, they are now responsible for being whistleblowers if there are any discrepancies or any suspicions. Many startup ventures don't plan to have a formal board of directors. However, it is good to remember that equity investors usually will insist on the formation of a board. The board of directors should be carefully chosen. Typically, you will find on board of directors individuals that have specific industry experience, people that have an extensive journey that they can share their learnings with you. And so they need to be willing to be informed, to spend the time to understand what is happening in the organization so that they can assist you in making those decisions. And obviously, they need to be willing to share their learnings. As a best practice, it's a good idea to select an odd number of board members. You could also choose to have a board of advisors. A board of advisors would be more loosely tied to the organization because they would serve only in an advisory capacity. A board of advisors has no legal status, so it's not subject to the regulations of the Sarbanes-Oxley Act. The board of advisors meet less frequently, depending on the need. And the board of advisors is very useful in family business because in family businesses, the board of directors may consist entirely of family members. The selection process for advisors is very similar to selecting a board of directors. Advisors could be compensated on a per meeting basis or with stock or stock options. Members should be evaluated as to their contribution to meeting the mission. All in all, board of advisors, they can provide a reality check for the owner. And because they're very flexible in size, background requirements, number of meetings, and compensation, board of advisors are a very desirable alternative. Aside from these, the entrepreneur will usually need outside advisors. I'm referring to accountants, bankers, lawyers, market researchers, and so on. When looking for advisors, you should be looking for the best advisors that you're able to find, and you should involve them thoroughly so that they have all the information that they need in order to advise you. Hiring and managing outside experts could be viewed as hiring advice suppliers. And even after the advisors have been hired, the entrepreneur should question their advice. Sometimes, if you're in doubt, you might feel like you need a second opinion. And you should, by all means, do that. So, not all of the experts, even if they are highly recommended, will provide the best advice. You should also look for people that have some affinity to your company's culture. You should feel comfortable with them, and they should be people that have the time to understand your business. In summary, thinking about and planning for an organizational structure is an important part of your venture's success. And so you should do this in a very thoughtful and reflective manner, because this is the team that will be helping you along the way to get to your goals and to your success. Let us now look at a specific process of steps that you need to take in order to initiate your business. And so for this, I wanted to point you in the direction of this website from the Texas Economic Development. And you have the URL, you can see it there. And this actually lists all of the steps that you need in order to start your business. It actually talks to you even about writing your business plan, and it even takes you to templates that you could use. Talks to you about choosing your location, financing your business structure. This is where we are right now. And it tells you what you need to do. So for example, if you are a sole proprietor or you have partners, you need to register and file the business name with your local county clerk's office. And if you decide to incorporate, you would need to go here, the Secretary of State's office, and then you can register the legal entity. You will also be able to find some FAQ videos on business structure and registering specifically in Texas. So make sure that you take a look at those. They will be pretty useful. Then here on step 6, you will be able to check to see if your venture needs a business license or permit. This is dependent on business type. And so you will be able to access here the Texas Business License and Permits Guide that lists all of the businesses that are required for persons who want to operate a business in Texas in that industry. Lastly, it takes you to business employer requirements, and then it gives you a list of other resource organizations. And with that, we've come to the end of the chapter. If you have any questions, let me know. Otherwise, just go to Blackboard and see what's next. Bye.